All right. Well, I'm sure we'll have some people coming in later, but we'll just all give them dirty looks because they're late and you guys were all timely. So thank you very, very much. I'm Liz Moneymaker. I'm your host for Lunch with Liz. And usually one of the first questions I get is Moneymaker my real last name? And I promise it is. It was my dad's name, his dad's, and many generations before that. I promise you if I made up a name, it probably wouldn't be Moneymaker for sure. And my law partners are John Ferrari and Sierra Butler. And if you have a Ferrari and a Butler, you obviously need a moneymaker. So that's where I fit in the mix. Thank you for joining me on this month's Lunch with Liz. This is we're into our fourth year now of doing these monthly webinars. And the reason I don't do it in the podcast format is because I like to have the engagement. I like you guys to ask questions and get your questions answered in a very casual free environment. Obviously, we're not going to be able to give you specific advice on your situation today, but we're going to give you some general advice that you can take from there and then extrapolate to your own business. So how today is going to work is I've got Starlett, who I'll talk about here in a second, on as a guest. Sometimes I get tired of talking, so I got to have a guest star on. So Starlett's my guest star this week. So we're going to talk a little bit back and forth in sort of a panel discussions way about business succession planning and how it works with your personal estate plan. And then we'll open it up for questions and we'll look at those periodically throughout this next hour. You can also raise your hand, come on video, and just talk to us. We love that. No requirement that you turn your video on, but we like to see your pretty faces for sure. So today's topic is business succession planning and how that relates to your personal estate plan. My practice focuses on your personal estate plan, but I work hand in hand, oftentimes with Starlett, on how to mesh the business with the personal estate plan. I want to give you just an example of something that I know about why this is near and dear to my heart. Is I had a very good friend of mine who owned a plumbing business, and he had an LLC that was the plumbing business and an LLC that was the building. I didn't know much about how his business was set up. He was very successful, it seemed like, in the Tampa area, and he died suddenly. Died suddenly with a very limited personal estate plan, which included a will, but no plan for the business. So no plan for the building, no plan for the plumbing company. So there was no way to transfer ownership of that company without going through probate. And we'll talk a little bit about probate today, but it is one of the words you don't want to hear. Not only is it expensive, it's also extremely time consuming. And it's the time that really made a difference in Billy's case because no one was able to pay his employees because no one had the authority to do that during the probate process, at least for a period of time until the court ordered someone to be able to do that. So that's just a little example of why this is really an important topic. And if you're on this call today, you either have a business or you're thinking about having a business. So it's important that we talk about how you set up your business estate plan just like you do your personal estate plan. So with that, I'm going to welcome my good friend and colleague, Starlett Massey, onto the call. Starlett is, well, I call her an expert. She's an expert in business formation, business governance. She's my go-to when I have questions about what is the best way to formulate a company. How do we figure out a way to sell the company? How do we figure out a way to pass this company on to the heirs? So I'm excited to welcome Starlett on. Welcome, Starlett.
Thanks, Liz. It's really a pleasure to be
Good to
here.
meet
And
you.
I see some familiar names and a couple of faces, which is really good to see. Hi, everybody.
Yeah.
We'll keep this really informal and I'll try to be as plain English as possible. You know, we lawyers get into legalese, and I am guilty of that. But I hope we've come up with a format that'll make this information really accessible to you all as business owners.
Absolutely. We'll definitely try to do that. And again, going back to the questions for those of you guys that may have come on a little bit later, you can raise your hand, you can come on video and ask, you can put it in the chat. You don't have to wait till the end either. If there's something that you don't understand that we're talking about, which could happen, we're just having a conversation with you today. Please let us know because what we don't want to do is you've spent an hour of your day here with us. We want to make sure that whatever reason you got on here and wanted to chime in, that you get your query or your question answered. So with that, let me just start how things usually start with me is I get a client in for their consultation and we're going through their questionnaire and we know that they have a house potentially, they've got investments, they've got bank accounts, and I also see that they have a business. So we'll talk about the business. We'll talk about what type of business it is. Is it an LLC? Is it a partnership? Is it a corporation? And then my next question is generally, well, what does your operating agreement say? What does your shareholder agreement say? Or what does your partnership agreement say? And 99 times out of 100, my clients do not have those documents. So Starlett, that's my first question to you is what are these documents and why are they important?
And that's something we both run into a lot. I think there's a misconception out there that you can form a company, be it an LLC or a corporation on sunbiz.org, and you own a company. The problem, and I bet most of you have heard of something like this happening or encountered it, hopefully not yourselves. Anyone can go in and file an updated annual report. So really, what's filed with the Division of Corporations is not that reliable. We don't have agreements with specifics between owners that are all recorded on Sunbiz. It's really just telling the state who you're saying the representatives are. A lot of times with an LLC, we disclose the manager, but we don't disclose the members or the owners. And same with a corporation. We can disclose directors, but not owners. So you don't get a lot of information that you can rely on from the Division of Corporations. Where we find the real information is in the shareholders agreement, in the share certificates for a corporation, or in the operating agreement and membership certificates for an LLC. And I'll just kind of lump all of that together and call it the governing documents for the company so we don't have to get too in the weeds about the different types of companies. But whatever type of company it is, we need to have governing documents that tell us who has ownership and what amount and type of control they have over the company. That's the first step because when we're looking at a business succession plan, we have to know where we are today. And sometimes, spouses or friends will own companies together and they might have talked about it 20 years ago and they've operated as if they're 50-50 owners or 50-50 in control, but nothing says that. And then things change. So there's lots of reasons you can come to, Liz or myself, and maybe the status quo has worked, but when we look to the future or, a current situation, we need to document those governing documents for the company.
And when it comes to what the governing documents do for the companies, what different things do you ensure that are in those documents that pertain to business succession or their personal estate plan?
So that's a big question. If we're looking just at business succession, right? What my preferred approach is that anybody who owns a business has a revocable trust. And it seems like that's a big ask. A lot of people feel like revocable trusts are only for multimillionaires. That's really not the case. In my opinion, a revocable trust is appropriate for anyone with minor children, a more modern family structure, a business, if you have more than just your homestead as far as real property. A revocable trust will save a lot of headache in the end.
Yeah.
Because if I have a client with a business and a revocable trust, I can implement that revocable trust. I guess everybody knows what that is, right? We're assuming that, Liz. You're
Well, if they don't, we'll do another one with Liz on what
okay,
a
okay.
revocable trust is. Yeah.
So it's a way to avoid probate. I can plug that into the governing documents for a business. And even if you make multiple changes to who your successor trustee will be, your business will follow the succession plan laid out in the trust. And these get surprisingly more specifically tailored than I think people would expect, because sometimes you might have one person that you designate as the financially responsible party. You might have another person who is a beneficiary, but you want them to have sign off on certain activities and not all. You might have someone you want to appoint as your successor manager who has ownership or doesn't. So there's lots of different things you can do to ensure you're not putting your business's ownership in a position where it has to be probated. But worse, I think back to your friend, and we don't want to see no one in control due to death or disability of a single owner of a business where you can't make payroll, where the company is literally forced to violate labor laws. And you're creating liabilities just because there was nobody appointed who could take the legal authority to take the reins of the business. And so it saves a lot of headache and in some cases preserves a lot of value in the company if you have a good business succession plan. Now there are limits to that, right? Like I don't know if there's any other lawyers on the call, but like, for example, a law firm can't be owned in Florida by anybody but a lawyer. And sometimes like a construction company has to have a licensed GC. And so sometimes in certain situations, certain types of businesses, we have to implement something like that within the business succession plan that also ties to the estate plan.
And what if someone wants a particular person to get the business, kind of in that same caveat, Starlet, when they die, but they don't want that person to run the business because they may not know how to run the business. Like, let's say it's a mechanic business and you want your wife to have the business, but she's not a mechanic. How do you make that happen in your planning?
So in businesses, and this is where those governing documents are important, there's really two categories. There's ownership and there's control. So you can be an owner with minimal control and basically get the profits or be responsible for the losses. Um, so you're getting the income, right? Or you can have a lot of control and have zero ownership or just a small percentage of ownership. And we can get really complicated with these things, or we can keep it really simple. For some customers, it seems like the best approach is to create levels of ownership interests, right? And for others, we can just say, this is the person ideally that would be the manager. And we're going to give the person who will be the owner authority to replace them. But this is our recommendation, right? Because we can make recommendations in our trust and our business succession plan. But sometimes we are going to allow somebody who would be a manager to have partial ownership after, if it's my firm, let's pretend we don't have that restriction on non-lawyers running law firms and I want to appoint Liz to run my firm, but I want my son to receive the profits from the firm. I could say, well, Liz, I'm going to give you 10% or let you buy into 10% so you have a stake in the game, right? A stake in the outcome. And we might want to put something in place on the front end as to a buy-sell agreement, right? Because what we don't want to do is set up our heirs for problems. Sorry, I'm losing my light in here. Um,
That's what you get for being energy efficient.
right. Um, so there's lots of little nuances to it. I don't know how much you want to get into that. If it's pretty rare that we have the buy sell agreements that we have to put in place, but sometimes they're there, and we have to do a restructure of how ownership is owned between the various people, or employees who we want to give the opportunity to have ownership to.
Yeah, and you and I were discussing that employee thing. Is I've done this in the past where clients have a business and they have loyal employees and they want the employees to be able to purchase or have the chance to purchase the business if the owner passes away. Can you kind of give our audience a little bit of advice on the pitfalls of doing that if you're not very detailed about what your intent is?
It's treacherous, right? So imagine, I have a company and my right-hand woman has been by my side for 20 years as an employee and a manager, and something happens to me, I'm not in the picture. That employee, if she has the right to buy 50% of the company from my estate or my trust, how do we determine the purchase price? And now I'm no longer, the leader and in charge with the authority to dictate things and say, well, you're fired if you don't do it the way I want to do it. You're putting your heirs in a position to have to negotiate with somebody that they may not know at all. And so we have to be really, really careful when we're giving the opportunity to buy in to our companies to employees, because you really are creating the risk that your current employee ends up in litigation with your beneficiary, the person you intended to help. And so what we have to do is go to industry norms and pick a formula, and everybody agrees in advance. If she exercises, this hypothetical manager exercises the right to buy that interest in the company, here is the formula we will use, and we ensure that the value can be determined from very clear data sets, right, that aren't subject to dispute. Because where there is dispute in what a company is valued at, you end up in a battle of the experts, and those are terribly expensive, because you could get two forensic CPAs and could use different methodology to get to the value of the company, and you can end up in front of a judge arguing what the real value is, all while the company is likely losing value because we're not focusing on the business, we're focusing on the company as an asset.
Okay. All right. Thank you. Thank you. Um, Anytime you guys have questions, let me know. I'm going to kind of run through a couple scenarios and Starlet, you can just chime in if there's anything additional you want. So let's say you're a husband and wife and you own an LLC. You don't have any operating agreement. One of you passes who owns the 50%. The 50% does not automatically pass to the surviving spouse, just so you know. The surviving spouse would have to probate to get the 50% that was owned by the spouse. So that is a very common scenario that happens. Same thing with if you're in an LLC with a business partner or any type of arrangement with a business partner. If you don't have these operating agreements or partnership agreements in place, along with your personal estate plan, then you're going to be probating that business. And what probate is you open a court case, you have to have an executor appointed. And generally speaking, probates take about a year, and it could take longer if there's a business involved. So that is the biggest reason why we strongly encourage business owners to have not just their personal plan in place, but their business plan in place that all works together. Anything to add to that, Starlet?
I feel like we're telling the negatives, instead of the positives. But I know when I created my trust and my firm succession plan, it really helped me sleep at night. I talked to the people involved, everybody knew what their responsibilities would be. And, I know that I have the best kind of asset, protection, liability shields in place. And it really, you are, because we're all going to eventually not be here, right? It is the most efficient way to get to the end result that you want, because we're building these businesses and accumulating wealth for our beneficiaries, right? We want everybody to be okay. And you can structure it pretty pretty directly, right? Where everything will flow, and the control will pass automatically, and you don't have to worry that you've created this need for litigation after the fact. That's the last thing that our heirs and beneficiaries need.
Right. And can you give an idea? Let's say somebody on the call is curious and wants to come meet with you. What's your process? What kind of information are you going to be looking for?
So let's say somebody has a company that they don't have governing documents for. Assuming that the ownership and control has stayed the same, this is not a heavy lift.
Mhm.
This is something I can do for a flat fee and just specifically tailor the documents to incorporate a revocable trust. We might be talking, 2 hours of work. It's not a big lift. Where it gets more interesting and more involved, and this happens sometimes, is business owners have made verbal promises to employees, to partners that they need to paper. And sometimes the way we communicate verbally doesn't easily like convert to legal documents and the state laws governing LLCs and corporations. But the good news is we can contract for literally anything. We just have to know what promises we're trying to document, right? It is all fixable. And so that's my job. I find out what promises and assurances we want to make and we document them.
Can you give an example of that? I know what you're talking about because I know that case, but can you just give a hypothetical to our group about what you're meaning about promises, verbal
Sure.
promises?
So I have a wonderful couple who owned a couple of businesses, and they had key employees who they had promised 10% of the company to when it sold. So whenever it sold, anytime in the future, those employees would be entitled to 10% of that purchase price. It seems on its face like a pretty straightforward promise, but it isn't that straightforward to document because we had to get the CPA involved, make sure there were no adverse tax consequences. And what we ended up doing was creating a parent company that could have levels or tiers of ownership interests. So we could give those employees 10% ownership, but zero control and zero access to books. Because sometimes that was the intent, right? But it can be hard to implement. But again, anything can be contracted for. And that one did have a happy ending.
Yeah, we love happy endings. Sometimes we don't get those at all. Um, we definitely want to make sure we have time for questions. So if anyone has any, you can throw them
I
in the chat or
I
come
see
off
Christy
Zoom.
has a hand raised,
Yeah, go ahead. I didn't see that.
or it's a wave.
I don't see anybody asking any questions. Are we clear as mud? Because what I don't want you to do is go away from here going like, I don't have any idea what they were talking about. So I want to make sure it's clear. Um, hey,
Hey,
Jim.
Hey, hello, hello. I'm just wondering, does it and hi, Starlett. Does it matter the size of your company?
as
What
to
what
whether
what are the stumbling blocks? What do we need to know about? How do we get started? I guess is what I'm asking.
the size of your company doesn't matter because without a succession plan that incorporates a trust, whoever is left will be stuck probating that asset. And so the most straightforward path to resolving ownership of a company after the death of one of the owners, regardless of size, is going to be through implementing revocable trusts. And, I think it becomes more critical where the company has employees and payroll obligations and debt obligations, right? Because you have to have somebody in place to manage those things. But even if you have a small company where, maybe one of the spouses is the primary, operations person and providing most of the services, we can't, we don't want a situation where the surviving spouse is left holding the bag and can't do what needs to be done. So the starting point, and Liz and I sometimes, one of us will get a client in, and I'm like, the best way to solve this issue is for you to have revocable trusts, and then I can implement them. So clients tend to, they'll come into me and go to Liz first, or if maybe there's issues with a lack of governing documents, and they start with Liz, they'll come to me and we'll create the governing documents. Then Liz creates the revocable trust. So it really just depends on how far along the business formation has been taken.
And I know you've both explained this before, but reversible, revocable trusts.
Revocable. Yeah. I like to think of a revocable trust like a bucket. So instead of, Liz owning a condo here and bank accounts here, and I have investment accounts over here and a vacation home in North Carolina, Liz creates a bucket. And instead of Liz owning these things now, Liz's bucket. So Liz's trust owns these things. And so because it's an entity, it's the bucket, Liz's bucket, when Liz kicks the bucket, the bucket lives on because the bucket isn't a human being. It continues to live. So because you have your stuff in a bucket, you avoid probate because the bucket continues to own it. And the instructions on the outside of the bucket jive, that's the legal terminology, jive with the things that Starlett has created for the business governing documents. So the trust instructions say, okay, upon death, the business is sold, or upon death, the business goes to junior, or whatever the instructions are that the two documents together say what happens. Trusts are a great tool. They're not a tool I recommend to everybody, but as Starlett pointed out at the beginning, people with businesses, people with minor children, people with real estate out of state or investment properties, those are typically the people we're going to suggest they get a revocable trust if they want to avoid probate. Some people don't care about probate, but when we talk to them about what it really means for their heirs to have to go through the time and expense of probate, then they generally agree that the upfront expense of a trust is worth it for them and for their heirs, whether it's children or other beneficiaries. That's their
Okay.
down and dirty about a trust. I do a whole lunch with Liz on them, so yeah, come back and see that at the next one we do.
Okay. And if size doesn't matter, what about the type of business? Let it go.
You did that on purpose, Jim.
Does it matter the kind of business or um, I'm a solopreneur with a video production company. Is that any different than somebody who manufactures a widget?
It matters, but in the end, the best result, in my opinion, is reached by implementing a revocable trust as owner of the business. How we do it will be dependent on the type of business, the number of employees, who we want to be in charge after we can no longer run our business. But when it comes to business ownership and avoiding probate, I think a lot of people think if I own a business with my wife, then it would pass because of the marriage, right, to my spouse. But business interests don't transfer like that. You can't say tenants by the entirety or rights of survivorship when we're looking at ownership of a business. And not that anybody probably cares, but there's good reason for that, right? Because when we look at businesses, we have again those two areas. You have ownership and control, and those can be very different. So it really doesn't matter what kind of business you have. I will say when we look at liability protection, and Chrissy, I know you put your question in chat and we will get to you, I promise. Florida developed limited liability companies later than the other states in the union. And case law evolved differently. So there's this really funky and unfortunate twist in how LLCs are regulated and governed in the state of Florida. So in most of the 50 states, a single member or one owner LLC is protected from liability. So we'll imagine, a delivery company, one owner owns a vehicle, catastrophic auto accident, big liability. And in most of the states in the country, the individual owner would be protected from liability because of that company shield. But in Florida, there's another risk, and you don't need to necessarily understand the mechanism, but you can foreclose the individual owner's interest out of the LLC. So we're different here in Florida. And so in Florida, we really want to have two members or two owners of every limited liability company so that we have that true liability shield that a corporate entity provides. And that's, when a lot of times when people come to me, that's part of the kind of restructure is we'll add a spouse or somebody, even giving them a 1% ownership interest, if you have an LLC, provides a lot of protection that you don't otherwise have, but we assume you have.
And you may have covered it already, but uh, at the owner founder's passing, are we talking about or how much different is it to want to if the successors want to sell it versus continue to develop, to service their clients? Doesn't
So
matter.
it depends. If we have a revocable trust in place and that revocable trust owns the company, then the beneficiaries can basically do whatever the trust allows them to do immediately. But if there's no revocable trust in place, those ownership interests in the business have to be probated. And what's not good about that, other than the cost of probate, is any creditors of the business can have to be paid. And you would have to go through this lengthy process, and that whole time nobody has control and nobody can make decisions on behalf of the company. I'm not sure if that really answered the question.
Well, yeah, because that's you got to it there at the end. If nobody has control and the business is dying, it's losing value the whole time, right?
Right.
Right. And you don't have authority to sell equipment, like in your business example.
That's what I'm talking
Um,
about.
yeah, exactly.
Is there an 80-20 split, the universal 80-20 split? When people come to you, how prepared are they, or you're usually taking them from ground up?
I'd say the vast majority of business owner clients who come in don't have operating agreements or governing documents. They filed something with SunBiz, and that they thought that they were good. The vast majority.
I'd say for my practice, though, probably about 50% have something, but it often doesn't say what they thought it said.
Yeah.
I know Winnie and Chrissy had questions. Do you see those in the?
Yeah, Chrissy asked, I think hers was first. Do you have a list of what items should be gathered before an appointment? I need this done, but I want to gather everything needed to help prevent any added delays in gathering it all. And I'm pretty sure that's addressed to you, Starlett.
Oh, I would have thought it was addressed to you.
Yeah. Well, yeah, I don't need anything. I provide you with a questionnaire, and that's what I need to have our initial consultation. So I don't need the documents. I'm going to ask you whether you have them. So I don't review it at our first consultation, but you may have a different take on how you do your initial consultations.
I mean, if somebody has governing documents, I ask that they bring them. If they ask what those are, I say, don't worry about it. And we go from there. A lot of times this issue has arisen because of something else, like a personal guarantee on a lease, something like that. And if there's ever, the reason somebody's coming to a business lawyer, I would want to see anything that you think is relevant, but there's not much that I need to get started.
Yeah. And Christy, if that did not answer your question, just jump back in the chat and we'll be more specific. Next question comes from Winnie. Two people create an LLC with 50% ownership. I'm assuming that's 50% each. One has no heirs, the other has two heirs, and they plan to sell the business in 5 years. Also, there's a 20-year age difference. I don't see a question there, Winnie, so I'm not sure how to address that comment. So if you want to throw a question in or come off mute and indicate exactly what type of commentary you want from that, we'd be happy to talk to you.
I'm not a mind reader, but I can guess.
Okay, go ahead. You mind read.
Um, I think what we would recommend if we are presented with that situation is exactly the kind of situation where we would recommend that each owner, each 50% owner, have their own revocable trust. And here's why. Here's the fun thing you can do, because one has heirs and one has no heirs. So let's say owner A has two heirs, owner B has no heirs, and they each of them bestow 50% of the company in their respective trusts. I got confused on who's A and B. A with the two, we'll call them children for simplicity's sake. A with two children, it will have something perhaps in their trust that says, upon my passing, I want 50% of my estate to go to my two children and 50% of my estate to go to my surviving spouse. And if the other owner is the surviving spouse, then we have a situation where the ownership of the company can follow that estate plan, right? Because you can have one trust have the other trust as the beneficiary. And so that way you can, this is really common to have people like one will have children or they'll both have children from prior marriages, and two trust is always the right answer, literally always. Because then we can control, from the grave who gets what, because we make sure that we're taking care of our surviving spouse. I'm reading a lot into this question, Winnie. I apologize. I'm just making things up. But it is a good way to provide for your children if they're not shared children. And again, that might be a situation where the owner with the two children, their children would then own half of their ownership interest in the company, or 25%, 12.5% each, right? But it could be created where the other owner retains the entire control, because maybe those children don't know anything about training air traffic controllers, right? We have to figure out what the best approach is specific to each business.
And Winnie, if that did not address your question, let us know for
I
sure.
might be more surprised if it did address Winnie's question, because I went off on a tangent of hypotheticals, making things up.
Absolutely. Anybody else? We don't want to keep you if you have things to do today, but we want to make sure that you made time to come to listen to this. And if we haven't addressed what you thought you would have learned here today, please let us know and we'll address it. Jim, did you have something else?
Yeah, one more question. Okay, I've got my last name as part of the business. Okay, the web works, and if it comes time to sell it, or as I'm getting close to the point where I don't want to do it anymore, do you recommend changing the name, and if so, what kind of wrinkle does that cause?
That's definitely a question for me. I do help clients who are selling their businesses, either the entire business or the assets of the business. And it really depends what the buyer wants. I mean, your reputation is so strong in the community. If you perhaps sold your company to, an employee or contractor, they may want to keep the name. And so that's part of the goodwill and value that you're giving them in exchange. So it really depends. So when, like, for example, I'll do an asset purchase, sometimes what I'm transferring in addition to washers and dryers and equipment is also a fictitious name. So there's lots of ways to do it. And again, anything can be contracted for. We just have to figure out what promises we want to make to people.
And as a solopreneur, providing a service, all I have is my client list. I don't have the washer and dryer thing. I have computers and cameras, but
Well, Liz, Liz and
how
I
do I
were
deal with that?
Liz and I were just talking about that, when we have companies and at like for me, without me, what is the value of my firm, right? And your situation may be similar. So how we value companies, especially if we're giving others the opportunity to buy them in our succession plans, really matters because maybe the fair purchase price is going to be a lot lower than we would like to think. And so we have to decide what like methodology do we want to use and what do we want to create for our company's legacy? Do we want it to go on and empower, a future owner, partial owner to take that name and do with it what they will? And there's a world of options.
And you're in the same boat, right? You both are solopreneurs in a company where you may have a staff, but it you only have your reputation, right? Or is there some other metric that comes to bear when you're ready to sell it, you know?
Yeah,
I
your
mean,
name, your phone number, your website, all those things that would bring in clients would definitely be part of the package for sure. Um,
I see Winnie followed up.
yeah, so did Chrissy. So Winnie said if they want the children to receive some income but no control. I think you kind of talked about that already, that there are
I
ways to
was a
set
I
that up.
was a mind reader.
You were, yeah. And
Right. So
then
you can give the children of one owner an ownership interest, but zero control. And so basically, they're just getting residual income
Mhm.
at the other owner's discretion, is a lot of times what we want to do. We sometimes don't want to force the other owner to make distributions, right? Because that could hurt the company. We need to have reserves. So there's a lot of kind of nuances that we get into. And usually it's best to isolate control and make everything discretionary. So then the only time that those children could be guaranteed any kind of income from that company might be upon sale.
yeah, we were talking to you about the pros and the cons of that type of relationship and strings attached to that type of or organizational makeup for sure. So Christy responded to, thanks. I was thinking and assuming that it would be better to know all that I have in order to know how to proceed, like how many companies I have, any deeds, investment, etc. And what it sounds like that is covered in the first appointment and gathering up front isn't needed. I would assume that you would know that coming in. So if that's information you wouldn't know, then definitely do homework. I'll give you an example. Like when I have an initial consult with someone and I ask them about what bank accounts they have, what investment accounts they have, what retirement accounts they have. You'd be surprised how many people don't know. Like, well, I have I think I have a retirement account, but I don't know who the beneficiary is on that one. And I think I have another bank account from when I lived in Indiana. So they don't know that information. And that is vital to know for me to advise. So I don't necessarily need documentation, but the more you know about your situation, and I think Starla would be the same, then the more efficient the meeting is going to be, right? And the more apt we are to be able to give you advice because we have the information versus sending you back to get more.
Well,
So
and
maybe I misled you at the beginning by saying I didn't need any documents, but certainly would need you to know the information.
Well, and candidly, like when someone comes to me, we're gonna pull up public records on SunBiz. My paralegal will always ask for addresses of property owned, names of companies, and I'll have printed out everything that's publicly available for the consultation because not everybody remembers all the details right off the top of their heads, but we can pull quite a lot, and we do that to be prepared.
Mhm. Excellent. Yeah, I do the same. I always pull the deed, but I can't pull bank records. So that's something
No.
important that someone else brings. So hopefully that answered your question, Chrissy, and you're not like, well, I still don't know what I need to bring. So And then Winnie responded again, or interest in the company, surviving owner to own 100%. I'm not exactly sure if you're just commenting on what Starlett said or you have an additional question there. I would say that you have a very specific question and a very specific issue, so you might be better off actually, having a consultation regarding your specific issue and how you want to set up your company for sure. Um, any,
Probably
Go ahead.
one last comment. Probably the
Yeah.
biggest thing, the other thing that people will need is a good CPA, because a lot of times when we have existing businesses, we have to be really careful about transfers and future planning to avoid tax consequences. And I just want to be very clear that's not something I can do. I'm not going to review tax returns and know about risk of tax liability. So a lot of times I meet with clients' business CPAs, run it by them. So we kind of have to get the whole group of the team of professionals in and make sure that what we're proposing is going to be the best approach. But I've never had a situation where we couldn't solve a problem and document, again, those promises and assurances that the clients wanted.
Excellent. Any other questions? We've got about 10 minutes or so left. Oh, we've got one here. Shannon asks, do I need a separate trust made for my business, or can it be the same beneficiary as my personal estate? It can be the same beneficiary. It's one trust that talks to your governing documents for your business is
That was the
essentially what it
best way
is.
of saying it. You just made that up just now.
I did on
We
the
could have
fly.
used that. I could have used that for the last 4 years, Liz. We need the trust to talk to the business
Yes.
documents, and you
Yes.
can do that. And you can,
Yeah.
I like it because it's more often that people update their trust. We have, I mean, not me, obviously, falling outs or changes, divorces, deaths. Well, a lot of times what we're changing is who we appoint as our successor trustee, who our beneficiaries may be. And when we have the estate planning documents, the trust talk to the governing documents, you have a situation where you don't have to update the business documents. You can keep going back and changing the trust and make all your appointments there, and the business will stay the same.
Yeah. So for clarity's purpose, then the
Please,
trust
please.
would be where you're going to dictate the formula for sale of the business, for example, or that kind of stuff. Because you might change that, or would you prefer that to be in the governing documents?
I would prefer formulas for business valuation and sale to be in the business's governing documents, but who the people will be, who will have control or be the beneficiaries, that comes from the revocable trust documents.
Perfect.
So it's kind of like we're putting the people over on Liz's side with the revocable trust, and then the ownership and control of the business over on the business side, but they all tie together.
Perfect. All right, a few more minutes left. I don't want you to leave if you haven't had your question answered. So come off mute or throw it in the chat and we'll talk about it. Otherwise, have a great afternoon. We will see you next month. If you're going to join us next month, our topic is trust versus wills. What's the difference? So if you have a question about what a trust is and why it's different than a will, please join us in September, the second Thursday of September, which is the 11th, I think, for the next lunch with Liz. Starlett, why don't you throw your contact info in the chat? So if anyone wants to reach you, and while you're doing that, there's another question. I understand if I have a business partner, it can't be included in a trust. What happens if an LLC, where I am the sole owner, if the partner of another LLC? I'm not quite, Starlett, maybe that's more your area. If I have a business partner, it can't be included in the trust. It could be included in the trust. We can put in the trust that you want to leave your share to the business partner if that's what you want. Um,
So I guess where I'm confused, and I'd have to understand how the LLC solely owned by one person is a
Sorry,
partner to another
maybe it's
LLC.
easier if I do the question.
Yeah. Hey, Patricia.
No? Eh, So I had no a meeting and I was asking because I have different businesses. I am the solely owner of the most of the business, but this one that I have a business partner. So the person that I was doing the consulting, they told me that since this LLC, I have a business partner, so I'm not the only owner, it's not possible to include it in my estate planning. So my question was if it's like that, but in this LLC that I have a business partner, instead of my name, Patricia Leon, the partner is another LLC that I'm the only owner, if it's possible to include it in the trust.
Yes, it is possible. So if you have a 50% ownership or 100% ownership of a business, an
Mhm.
LLC here, and you set up a revocable trust, instead of you individually owning 50% or 100%, whatever the case may be, you would vest your percentage ownership in your revocable trust.
Mhm.
So it's absolutely possible, but it wouldn't be possible with a will. So I think that could be the difference. You have to go a step further in the estate planning and create that revocable trust.
Okay. Okay. Thank you.
You're
You're welcome.
welcome. I will tell you, you do sleep better at night knowing that you've put those contracts together and you know what your beneficiaries can expect, and I think that's probably the best part about getting this process completed. And yes, estate plans are living documents. Like I said, things change with the people you would appoint to handle things for you, but it doesn't have to be that complicated. Those changes are easy once you've got kind of the structure set up.
Exactly. And a cautionary tale is one thing that I see people do is they'll get on the internet and they'll get an operating agreement off the internet and they'll go to, some Susie Orman or something and get a trust from there. The two things aren't talking to each other. And also when you print a trust out from Susie Orman or whoever, right? That's an empty bucket is all it is. An empty bucket where you may not even understand what the instructions for the bucket is. So working with someone like Starlett, someone like me, we make sure that that bucket gets stuff in it. And by stuff, I mean your business, your real estate, your investments. So I always caution people to do it yourself, because when you find out that it was wrong, it's too late. Someone has died, someone's incapacitated, and it's too late to fix it. Um, Starlet's the positive person. I'm the one that does all the doom and gloom about if you don't do the things you're supposed to do. So
Well, you,
I
you know,
want
you never want to see bad things happen, but they do, and when they do, and beneficiaries can come to me, and everything goes smoothly, it really feels good. I feel like I've done my job, and that happens.
we have
Yes,
a yes.
people do absolutely put businesses in a trust. Like, for example, an LLC has what we call membership interests. That's what the ownership is called. And so if you have 100% owner of an LLC that is, Sue Smith, you could move that entire 100% into Sue Smith's revocable trust as managed by the trustee.
If no one else has a question, we are going to wrap up Lunch with Liz for August. Thank you so much, Starlett. You're brilliant, and I always love listening to everything you have to say, especially when it's related to business. So,
Thanks,
if you
Liz.
have questions that did not get answered today, Starlett put her info in the chat. You can set up a consultation with her. Vicky put her email in the chat too. That's how you would set up a consultation with me. In the meantime, have a great rest of your month. Get out there and fight the fight.